You arrived.
Yes,
Okay, we're online. So are we running, Greg?
Oh, is it
Yes.
running?
Yeah.
Well, you're aware that there had been this new exception introduced as of June last year for text and data mining, which basically says that anyone who had lawful access to material, which basically means you've got a license to get some digital material, you own the book, or ID that, anyone with lawful access to material who wants to do text and data mining for non-commercial purposes, and the debate behind what's commercial can do so without having to ask permission, without having to pay fees. And very importantly, this change in the law also said that if you have signed a contract which does not permit text and data mining, that clause in that contract can be ignored. That clause is invalid.
So if we sign a contract, or one of my colleagues, if I sign a contract saying that this is excluded, they could still do it.
They can do it, and that excluded clause in law is just ignored, it's just wiped from the agreement. Even if you signed it before, or indeed even if you sign it today, it makes no difference. You can happily sign it because you don't need to pay attention to it.
That's interesting. So how come so much?
Because they don't. I think it's actually
people know about Hargreaves, but I think people don't actually know what it means to them.
that crucial extra bit is no contractual override. It doesn't appear in an awful lot of copyright. Awful lot of copyright law says basically, if you agree something which is not in your best interest, tough luck, that's your problem. In this particular exception, it protects you. And I think that's probably the reason why there's so much ignorance, because people just assume the contract takes priority.
Because that would be my section, would be going to base the contract.
Yeah.
So you would assume that if you then start a content mining or data mining activity,
You're in breach of
contract.
Yeah.
So
Yeah.
then it comes down to the publisher of the R issue, whether they want to sue, whether they want to listen more.
And to be fair, the publisher is probably assuming standard license for the UK, Ireland, France, etc. And the UK is virtually unique in having this special exception. So why should they rewrite their contract if it's a standard contract?
Just for the UK.
Just for the UK.
So if the content that you're accessing is held elsewhere,
Makes no difference.
So what makes a difference is the point of the extra data miners they're not.
Yeah,
So if
correct.
it's held on server in
Absolutely.
Australia, for example, the laws are different.
Yeah.
It's actually the point of use.
Absolutely right. And it doesn't matter whether your license is with a US company, a French company, etc., etc., etc. The only worry I would have, actually, which has only just occurred to me, is if you have signed any contract, so I've only signed any contract with a publisher, and it actually says this is under the law of the United States of America, then there might be a potential problem. There might be.
So if a contract that you would sign predates
Makes a good, the new law overrides whatever you agree. Yeah, it's basically from the 1st of June. From the 1st of June, automatically, all previously agreed contracts, that clause gets wiped.
So as was it first read due to Hargreaves in the UK,
Yes.
we are. It's
It doesn't matter when you sign the contract, how long the contract is for, etc.
That's what we're
Yeah, it's interesting. So if you does it prohibit any particular types of content mining? Do they define?
The exception is actually quite badly worded in the sense that it says for text and data mining. It doesn't define what text and data mining
So
is.
does it say you can do it on an individual basis? Like
It could be a group basis. It could be as long as it's for a non-commercial purpose.
So what happens if you've automated it and you're downloading? Because we tend to when people are, it's you're notified when people sometimes are trying to harvest a huge amount of data.
Yeah.
Usually because they're trying to get around, they're actually behaving illegal. So we can tend to be notified that potentially people.
When you say you're notified, is that by the publisher? Yeah.
Because it triggers something. Someone's
Yeah, no doubt.
downloading
That's obvious.
it,
Yeah,
and
yeah, yeah.
and you think that they don't reach the right.
So the message you get is, you've had this much downloads. That's who the individual was or what the IP.
You usually get IP within.
Oh, you get it. Okay,
Yeah.
within an IP. Like downloaded 5,000 items on the 4th of January. Please investigate. Is that essentially what you get?
Yeah, basically, or you can be switched off.
It can be switched off. Fine.
So would that be liable to happen if you were doing a wholesale test?
Well, if they attempted to switch you off because of large-scale downloading when it was in fact permitted in UK law, you would have grounds for serious complaint against the publisher.
I mean, it tends to be something that potentially happens.
Yeah, well, sure, it gets sorted out. Yeah.
Yes, I mean, I've been cut off more than once by publishers for what I consider to be completely legal activity. Normally, when this happens, you get a message that says you must contact a senior person in the institute and show that you have reason to be reconnected or whatever. It's arbitrary and it's immediate.
So what do? You ring up the person?
Or email the person, yes. I would email Live.
Yeah.
You know, I might email Yvonne. Lots of people wouldn't know who to email, and so forth. And it comes out of the blue.
Yeah.
There is normally nothing to say. Are you aware that you are downloading more than...
Right, so you don't get any sort of advance warning in that sort of sense. It simply says, you've been a naughty boy, we've switched you off, don't talk to somebody.
Don't talk to someone.
Yeah.
Yes, indeed. And so that's happened 2 or 3 times.
Right. Well, you may well, if word gets out, and word should get out, you will you'll probably get more of these requests. And you need to investigate. And there is a sort of duty on you to make sure it is for a non-commercial purpose that they're doing.
So how did you find that?
Well, that's an issue.
Because say you're building up a data set potentially be used as a rival to something that publishers are providing. That is, there's an arguable point to be had. But where it's straightforwardly for what is normally called academic research, there shouldn't be a problem. Certainly is a problem if the person who is doing the downloading either is being paid to do it, it has got a deal with an external company. It says, can you do us a favour? We want to we'll pay you £5,000 if you analyse this collection of data. That's clearly commercial. Or indeed, if it's been collected, and as you say, with the intention of creating some competitive product. Are there boundaries in here for our hands as potential end users about terms and conditions of what you can actually do?
Well, Jenny and Charles have written an article for just called Responsible Content Mining.
Yes, something like that.
Yes.
Non-irresponsible content. I
think it was called Responsible Content, and the idea there was for us to anticipate what would be reasonable to do, and to put it in front of people, so that if there was no objection to this, people following us would at least know that they were in the right sort of book. So there are about 4 different reasons that publishers have advanced as to why text and data mining will be injurious to their activities. So the first is that it will put an excessive load on their servers. Now you try and counter that sort of thing by showing what the load from responsible text and data mining will be.
And that's interrupted. The new exception to copyright does give the publishers or the rights owners a little bit of leeway, because it says nothing done by the text and data mine should have a deleterious effect on the performance of.
Yes, so say you were downloading from a massive data set,
Yeah.
you were slowing down the speed of it.
If you were slowing things down or causing it to fall over, then they have justification in saying stop it.
But that seems reasonable.
Yeah, I don't know if their interpretation of it, which I don't find reasonable, where certain companies are saying, well, even if you take 100 of our items, that's going to knock our system over, and which is just nonsense.
What about the institution, if they're in a position, say, like, state mining, and they're actually saying that lots of their systems, it's 99% safe, is that an institution issue?
That's for the institution to decide, and certainly not the publisher's business. Yeah, that's an interesting question. If that were the case, and if you had researchers who were doing TDM and were thereby spoiling the service for other users, well, then that's internal politics.
Is it fair to say that at this juncture, because perhaps the arguments affects the 1st of April, it's going to be about 6 months for the waters to settle, but is it reasonable, and reasonable is a very legalistic thing, is it reasonable to say that we're still in uncharted waters?
Indeed, yeah, absolutely.
It's also fair to say that relatively few publishers have been proactive in making positive offers as to how this should be done. Most publishers have remained pretty silent. One or two have suggested that there are different ways of looking at it, and the publishers in general, through SDM publishers, have fought a political campaign in Europe for this to be done through the licenses of the publishers and the APIs of the publishers.
Rather than an exception.
If the publisher provides, say, their user base with an API, can they actually...
They can't insist on using
exactly.
It may well be a perfectly good API and may well want to take it up, but they can't say you must use
You must use that, so we're allowed to use content miners and we do use that.
So APIs have both positive and negative aspects. The positive aspect of APIs is that they are specifically engineered to allow machines to make large-scale requests and to have relatively efficient use of resources. The negative ones are that they often require you to have specific permission to use them, even if it's an automatic permission. No, you cannot use this unless you make a request. Secondly, that usually identifies you so that you're known to the provider. And thirdly, that they may be able to extract usage data and so on from people with or without their permission.
And of course, they may well impose conditions like you can only take so much per day or whatever.
So what if the publisher does not the exceptions that say the publisher sees somebody test content mining, and although the person who's doing it is doing it with no commercial basis in mind, the publisher can see the commercial opportunity there is potentially sticking and having revenue in the future, and they have to turn around and say...
That's an interesting question. I would personally argue that that's not a sound basis for complaining.
So this is something that potentially...
This is the problem with this commercial versus non-commercial. The general approach the courts have taken to that is, if it is clearly commercial at the time that the stuff was done, so for example, let's just say a publisher is already offering something and is worried that this is what this other person is doing, it might be competitive, then they might have a case. But if they don't have a service, and if the person is saying, I'm just doing it for research purposes, non-commercial research, I don't think they have a case.
It's potentially in a situation where by content mining activity you're doing, you're alerting, because of the type of thing you're looking at, you're alerting the data set providing the data set to something.
That could well be. Oh, what a good idea. Or downloading that particular subject area and creating something out of it. But that I think is too tenuous a link for them to complain.
There is an additional thing, which is some publishers create databases.
Yes.
Many of them by the sweat of their brow, to use a good phrase, and that it may be that text and data mining is a more efficient way of creating data in this area, and that they may regard this as illegitimately challenging their position in the marketplace. But to do so would imply that they had an effective monopoly and status on innovation.
Yeah.
And that might be...
I mean, I don't think courts will be sympathetic to that sort of argument, but the truth is, if the case ever came up.
So today, there should be no national courts on this.
Absolutely.
I just thinking of us the reverse parallel, flipping it over, from our perspective to that of the publishers and companies that we take, for example, the likes of Elsevier/Mendeley, who, regardless of the archives, they text and data mine for commercial purposes.
Indeed,
but we
that's true. That's true. Yeah.
So the power is still very much in the favour of publishers.
There's no question that the power...
Sorry to my Elsevier Mendeley friends.
Is but the publishers. Their argument would be, well, nobody's challenged this in court. Now the problem is that the people who are affected by that are individual authors in many cases. Sometimes it's rival publishers. So if you hoover up the whole literature and transform it in some way, then your rival publishers might decide to sue you. And in fact, it surprises me that in some of these the publishers haven't. But if you say, okay, well, I've taken an author's material, that author is very unlikely to have the will and the power and the ability to sue a bigger publisher and to get any rights back.
But there is the reputational issue which came up in this morning's discussion. It wouldn't look good if a publisher was seen to be squashing an individual or small group of scholars and thereby, stopping the promotion and stuff. They've got their own reputation to think of as well, and that is quite a powerful weapon at the end of the day.
Absolutely.
Yeah. And although, as we had this morning, motivation doesn't affect the absoluteness of the law, in many cases the motivation here is not.
It's altruistic. Yeah.
It's altruistic, it's looking for advances in human health or better science or new materials or climate change or whatever.
Well, that still doesn't count as a defence in somebody to do that.
Well, this came up this morning. It doesn't count as a defence, but may well reduce any penalty.
In real terms it does, but in legal terms it doesn't.
So,
not in the eyes of
I mean, we did talk about this this morning, the idea that if anybody has a complaint to make, there should be a notice and takedown procedure by the text and data mining group, whoever is doing the work, to say, if you've got a problem, let us know and we will, engage with you.
so what about law in different jurisdictions? What about law in the US?
Now, the law in the US is really woolly because it's fair use, and fair use is so vaguely termed that it could well be that a lot of text and data mining activities are okay under fair use, but it is ambiguous, whereas in the UK it's very clear that we have consumption. And getting on to Europe, the UK is currently one of only two countries which has this explicit exception, the other one being Japan. But the EU is now, or a member of the European Parliament is now talking about introducing a whole raft of changes in the law EU-wide in copyright, and one of the proposals is have an explicit exception to text and data mining. But it'll be years before anything happens because you've got to go through all the EU procedures, and indeed they will not happen because publishers are very unhappy and already lobbying against it. But it is possible that maybe in 5 years' time, if there'll be an EU-wide exception.
So taking it further, what if publishers were looking at the text and data mining?
Yeah.
And national too? I don't know, put barriers in the way, so actually put obstacles in the way of people who are actually doing it.
But the obstacle was to deliberately slow the whole system down, there is already in UK law a provision in the Copyright Act which says that if somebody does something to block your ability to do something which is illegal, it's under an exception to copyright law, you can make a complaint to the Secretary of State, and you have to send you've got to fill out a form and say, this person is stopping me, or this company probably, is stopping me from doing something which I am allowed to do under UK copyright law. Please, can you investigate? Secretary of State is then obliged to investigate, and if the Secretary of State decides in his or her infinite wisdom that yes, indeed, this blockage is deliberate and is unjustified, can issue a statement telling the company lower the barrier. But then, if the company refuses to lower the barrier, it's up to the individual to sue the company. So the whole process is slow and convoluted. And I personally would like to see a change in the law so if a barrier is introduced, it should be an offence. Full stop. None of this appealing to the Secretary of State, and the Secretary of State expresses an opinion. Just it is. So they can be prosecuted.
And it should be called the Oppenhein law.
Yes, I would quite agree. If that's my
no conflict of interest whatsoever.
Yeah. Yeah. I'd be all in favour of that. That would make me a very happy man.
From the practical point of view, it's not easy to do because it can only be put in the same pipeline, same access route as legitimate use.
And so we could probably slow everybody.
And
there's a reputational thing again, you know, this company is stopping people doing.
So, for example, and this is recorded factually, by pure happenstance, the American Chemical Society's webpage got triggered on a spider trap. Right?
I remember this.
Yes.
And as a result, it spread throughout the community, and 200 sites were cut off automatically.
Because you just needed to click on it and then.
Yes.
Yeah, I do remember.
And it got closed down, and that disadvantaged all the users. So, you know, my colleagues in chemistry were upset with the American Chemical Society for cutting off the.
Understandably.
Would it be fair to say that the spider ended up biting its own ass?
Not on there, I don't think. Jenny, you've just arrived, and we're having a conversation.
I'm sat in front of the thing.
We're having a conversation.
Sacred stage, that'll be 10 times.
We're having a conversation with Yvonne and Charles about libraries and the new Hargreaves
Just asking
legislation.
questions from because I'm very aware of the wider library community. As people, they may know the extension of it, but they don't know what it means yet in practice. And
I'm just wondering whether,
Jenny, we are on there.
yes,
whether if you could think of a vehicle whereby I could say write an article,
that would be fantastic.
but what would be the best place for it to be put for a large proportion of UK library academic library would read it?
That's interesting. Some of the say public library.
Absolutely. Yeah.
And I've read it to Stuart.
Yeah.
But
But you see an art group, does that have a newsletter or?
I'm not sure.
Does RWK have a newsletter? Very well then.
It must have distribution list.
Yeah, that's good.
RWK do the most of stuff online as opposed to, I don't know actually.
Yeah.
They might do it too.
Yeah.
Might post it.
Oh, they might. Yeah,
Yeah,
they might just have a guest blog or something like that.
They do,
Yeah. Yeah. Okay. Well, if we communicate after the event and
because I know they have a blog, because the most recent thing they had on it was to do, but I know from working in the librarian that that's actually really special research. And they do lots of library mailing lists as well, which cover the general library mailing lists as
of
well.
course, yes. if the blog say appeared on the RL UK and just gave the URL for it on other lists. Yep.
No, we make sure this is on the website as well.
Absolutely.
Yeah.
We're good to be able to just also just kind of simple guidance. It's like FAQs. Sometimes those FAQs are absolutely no use, but anything that I have a problem and actually says it's right and I'm doing something and actually and then by the next time I'm going to find it and proceed on and something else.
And you can also have a N FAQ, not frequently asked questions.
That's a good point, actually. It is because it's that really obscure thing. And then somebody you can actually contact.
I'm very happy with that.
That's your job.
I need a lawyer. Oh, hello.
But it does worry me, as you said right at the start, librarians either don't understand or are very nervous of
I think they're nervous, and I think they're nervous when they're outside their own. I think in Cambridge you're seeing an exception anyway because you're working people are doing this stuff. So to us, we're used to stuff going on, and most people aren't. So we're in a position of having some knowledge, but other people aren't in that position. So they know these initiatives and their academics know nothing about it. But they're not skilled, they just haven't got the skill set. And I mean, it's always got that management skill set that's changed the whole time. So you have people who are doing much about copyright law, but even so, this is a new departure.
It's a new departure, and the implications.
Again, very back to on chapter borders.
It is, really. And I think that's a major issue.
In a good way. But also in a complex way.
Well, one of the dangers, I think, of the fact that it's not widely known is that people may carry out actions which are then seen as precedent.
Yes.
Yeah.
And that worries me. So, for example, about 3 years ago, Heather Pivovar in University, that's right, wanted to do text and data mining, and she negotiated with Elsevier. And that was long and protracted. It put her under a great deal of stress, which she admitted publicly. And as a result, there was a specific agreement with the University of British Columbia for her to carry out certain projects. And that's the way it's been up to now. It may be that some people will continue that way. And what worries me is that we will then have the position where publishers will say, libraries actually don't want this. They prefer to negotiate with us directly, or researchers don't really want it, and so forth. And it's used as a way to show that this is not important, that nothing needs to change, and so forth.
That's why in the UK we have an advantage, namely JISC and JISC Collection, who can negotiate on behalf of the community. And they're certainly aware of the change in the law, and hopefully will be much more robust with their future negotiations with publishers to ensure that the contract, in fact, the current standard JISC contract is okay, because one of the clauses says nothing, it literally says it in writing, it won't say nothing, it says nothing in this contract shall prevent somebody doing, a user, from doing things which are permitted in law.
Okay,
so it's already embedded, irrespective of the fact that such clauses prohibiting GDM are not valid. We're already covered with most of the JISC standard contracts. And that's an important clause to have whenever you sign a deal, is to have that embedded.
And also for those listening in, Content Mine and JISC ran a joint workshop in December last year, so just about a month ago, with a very good attendance from JISC staff, and these issues were discussed, and so there's great knowledge in JISC about both the politics, legal and technical aspects of text and data mining.
I'm not sure it's right.
Yes.
And I'm not sure that just legal outside of the party have anything on it.
But we can certainly talk to new vacancies or whatever.
Oh, absolutely. I get it. Yeah.
I mean, we do need to follow up through them because quite a few people said that they wanted to be kept up to date. We'd be happy to be part of this and discuss more about. And just within some of the reflection, motion.
Yeah. It's a good question.
Want to find out? Yes. I think, one of the things is that the visibility is still so low among the groups that, librarians won't get the inquiries because the researchers don't know they can do it either, and it just goes
And at the moment, I think the likely things that will happen is, first of all, I think many researchers will not know anything's changed, so they will either they will continue to do what they've been doing, which is either carrying out mining activity without actually alerting anybody to it, or they will believe that it's so difficult or it's illegal or whatever.
They're scared.
It just would be back to just how to just quickly change the sense of social media. But if you search just for TDM, there's nothing. If you search for text data, there's 53 things that come up. But I didn't get a chance.
Okay, well,
but there's information there. Yeah. The most recent is the value and benefits.
Oh yeah, because a lot of those hits will be that report.
Yeah.
Oh yes, of course they did the report.
That's
their
but it will be useful to know if they've put anything in since.
Yeah.
But it seems to be the TDM report was well thought out.
Absolutely. Well, a couple of years ago,
It was about that, and that highlighted that the reuse of data in biomedical was of the order in Europe of 125 billion a year or something of that sort. It wasn't just text and data.
No. But they said there was lots of potential.
Yeah.
So what was the publishing reaction to Nobis?
They hated the text and data.
I wonder why.
They were furious about it. When Hargreaves originally started his, research for the report, I don't think text and data mining particularly came up. But when he published the report, there it was. At that point, the publishers were furious. So it basically said, this is the end of civilization, we know it. But the government, bless its cotton sock, stuck with it and introduced the change to the law. It's possible that extra clause about you mustn't do anything which degrades the quality of the service which the supplier gets might have got introduced as a result of publisher pressure. But yes, and now it's been proposed that this should be extended to the EU, and publisher reaction to that has been furious.
If you back to just the report was updated on the 15th of January.
Yeah.
But I didn't get a chance to actually see whether it was a full stop or something.
So, Yvonne, from our point of view in content mining, we have now got post-alpha versions of the technology, right? And that's what we're doing at the HFK. Yeah. With the result that one of our future activities in the near future will be to mine the literature on a regular basis, probably daily, and to extract facts from that using our automated software, and to make the facts which are not copyrightable available under a permissive license such as CC0. So that's alerting you to the fact that that's going to be done, and that will be done because we believe it to be completely illegal in the UK. A positive side of this is that people who want to do research, which depends on that, as far as I'm concerned, are more than welcome to collaborate with us on research projects. And so if people like Jenny, who's a member of Cambridge University, or me, or Richard or Steph, find that somebody wants to work on something which is mutually interesting, then I'd be very happy to put my own effort into it. So that again makes it completely legal. And one of the things that the UK IPO was very keen on, Intellectual Property Office, was that this should be seen to have positive benefits. And so that if we can show that people want to come to Cambridge to do research because it's the world centre for content mining, then I think the IPO government.uk would feel that that was a partial success of the new model.
And also, from what I understand, the financial benefits to society at large of TDN are massive. In a positive sense.
The conundrum for us is that we cannot use this material for our own commercial benefit. And and so we have to be clear that what we publish, other people can make money out of it.
But that is helpful. Well, helpful in the way that it ensures you're not going to break the law, but it's unhelpful in the sense of, well, how is content mine going to continue in the longer term?
And also, how's it going to show an economic benefit?
How's it going to show an economic benefit?
UK?
I've got another question, which is so what about publicly accessible food data sets? Can you,
That's fine anyway.
or is that fine? I want to check. I mean, just because something's publicly accessible.
Well,
Does that mean-
presumably under what license it's available. We did skim over this morning, and we're skimming over this afternoon, the question of database right, which is a separate right. And the crucial problem with database rights is that this exception does not apply to database.
Right.
So where a database enjoys database rights, and actually not that many do, but some databases enjoy database rights, unfortunately, you have to negotiate with the owner in order to.
Is there lots of databases and repositories or data sets, not databases?
Yes.
This person who may have published that data, and it's not commercial at all, and you can feel it not commercial data, but it's possible that somebody else using text and data mining.
Absolutely.
There is
Absolutely. But that's true of everything Creative Commons. You know, there are people who can take advantage of Creative Commons materials and make money out of it if they so wish.
Individual things in the actually a problem.
Now, the next one is to take the Texas brother from Scotland. One who's still sick. You're all right, folks.
So does that give you an idea, Yvonne, as to where we're going?
Yeah, definitely.
Some of what we do will be done from outside the paywall, so that really shouldn't concern anybody because it could be done by anybody in the UK.
At any time.
Anybody in the UK can point their machine at publishers' free-to-view websites and mine it for facts and republish the facts, and that will break any of the existing laws. Going behind the paywall requires somebody who has a right to do it, which includes half the people in this room and excludes half the people in this room.
As long as it's legal.
Exactly.
As long as you're acting legally.
If you've got lawful access, and if you have lawful access as a member of Cambridge University, who and Cambridge University has got a license to that.
And then
I mean, there's nothing in it.
and then all
Sorry. If I go to the Natural History Museum as a visitor, especially with you, and with their own terms and conditions for access that I sign as the utility specialist, am I bound by that?
Then you might be bound by their terms and conditions in terms of we grant you access under the following conditions. And I mean, just for example, if you were to go to the Natural History Museum to inspect their copy of Audubon's Bird, and you photocopied every page and then walked off with it, and even though it's out of copyright, they would be able to say, hang on, that's against our rules, assuming it is against our rules. if you've damaged the book and slammed it on the photograph or whatever else it might be. So they're entitled to impose their extra rules.
But I would only have a problem with them publishing it.
Yes, exactly.
So they would
Correct.
have
Absolutely right. Yeah.
So I was in the VR
That's
the other day, actually, and there were books and they were saying, I went to an exhibition, but we couldn't photograph the books. So I was thinking, actually, I really want to photograph this. Just,
Yeah,
you know,
absolutely.
sentimental
Yeah.
reasons.
But they're entitled to impose whatever condition they like.
And of course, Ross, they might not let you back.
Yes.
Which is another factor, yes. So, why would you want to stick to those?
So, Yvonne, one of the things that we are very keen to do is to make our tools and services and training available to libraries. I mean, you've highlighted that this is a problem, that not everybody in libraries is aware of what is possible and the details of it. So, we've now proofed our training courses, and they've been delivered to a considerable number of different types of organisations. So we're just saying to you and to the world that we'd be very happy to come in and run anything from probably a 2-hour workshop to a 2-day workshop.
Actually, let us trigger off another thought. In addition to possibly writing articles, presentation of UKSG or something like that.
And in fact,
Do they have special?
Yeah, because UKSG.
That's UK serials.
I know,
Yeah.
I presented 2 years ago.
Oh, right. Oh, okay.
Because that was in one of their points, because you presented. And also because I think.
It generated some discussion.
Yeah, I
didn't it?
think it might have been. Was it the one in Gordon from the
I went,
I don't know if it was the last one.
No, it was even before. It was Bournemouth I went to, then I think I was watching presentation. Because logistical reasons for kids, it was easier to do Bournemouth one. But UKSG this year, they are looking at.
That's Glasgow.
Yeah, and they're looking at open data.
Although,
They
that's
are.
not a million miles away.
No,
is
it's
it?
not. And in fact, and research data management, which is.
Yeah. So there's another possibility. I don't know whether, but presumably the program is already set.
I'm sure it was sessions.
Yeah, because they normally have parallel sessions with.
And I also pointed that as very some of the
I'm
stuff
sure,
when usually
absolutely. Yeah.
I can second it, because it's a view.
I mean, it was not bad when I went. One of the bad things about these conferences is you often get product clubs.
Oh, yeah.
But you do that, okay?
That's what
But
keeps
there weren't
UKSG.
too many of them.
Well, let's see, it's still expensive.
I've only ever been as a freebie because I've been the speaker, so I've no idea how much it was.
Delegate rates are quite
Is that including accommodation? Or
No,
Oh, it's really expensive.
That is
well, it's, people are, sort of all seated. There's lots of manufacturer, and vendors there and so.
Yeah.
I only go if I'm invited.
Yeah.